So I'm Aidan Pollitt, and I'm the chairperson of the Board of Trustees for CASCAIDr, the Centre for Adult Social Care, Advice, Information and Dispute Resolution. CASCAIDr is a specialist advice charity launched in 2017. Our mission is to try to help put right some of the not so good things going on in adult social care and NHS health service allocation in this country. With me is Dr Laurence Clark, academic, critically acclaimed stand-up comedian. He's written about various disability equality issues for The Times, Community Care, Disability Now. Laurence has been a guest reporter on BBC Two's Newsnight and is more recently script writing for Channel 4 and the BBC. A user of self-directed supports himself since 1992, Laurence's MA dissertation examined the effects of community care charging policies for personal assistance users. And I'm also joined by Belinda Schwer, CEO of CASCAIDr, barrister, solicitor, trainer, campaigner, and anything else, Belinda, you want me to add to that list? And,
just general exhausted person at this moment.
And welcome to you both anyway. And today we're speaking about the contentious issue of charges that are levied by local authorities against many people who require social care services. We will specifically be talking about a campaign being run by CASCAIDr in the wake of significant ruling of the High Court called SH versus Norfolk Council 2020. And basically arising out of the Care Act 2014, when a person appears to need social care by a local authority, the authority has a duty to do a number of things. They must conduct an assessment of the person's needs. They must ensure that those needs are met, or at least offer to ensure that the person's needs are met, and as necessary, provide a care and support plan. And they must, in the course of discharging those duties, conduct a financial assessment to figure out really if the person can pay for those services themselves, or at least can contribute to the paying of the services. And many people find the whole regime of charging for care services complicated and complex, including me. But coming to you first, Laurence, then, bearing all those things in mind and to set the scene, well before the Care Act in 2006, you wrote a dissertation about care charges. What was the focus of your dissertation at that time, please?
Well, I was quite opportunistic at the time because I was at the Edinburgh Fringe that year. So I made my dissertation a comparison of England and Scotland in terms of care charging, because I knew I was going to be in both places. I interviewed people in both countries, and in terms of the effects, what I found was that the one that stands out was quite a heartbreaking story of a woman who had been left quite a lot of money by her parents, and I'd seen absolutely no benefit of that money because the inheritance took her way over the threshold, and the local authority basically made her pay for the full cost of her care, and she needed substantial, I think it might have even been 24-hour care, until that inheritance dwindled to below the threshold. So it effectively meant that she was able to inherit from her parents. I interview people on various benefits to do with being out of work and being unable to work. And basically charging just took away all of the niceties of life. It left them with enough money to feed themselves and survive, but absolutely nothing more.
Mm.
I mean, the guidance around charging, I mean, the government is very, very keen that charging shouldn't be a disincentive to work. So the guidance makes it clear that earned income can't be taken into account. However, what I found was that the kind some of the benefits of working, such as saving money for a new car or a new house or whatever, or putting money in your pension, suddenly becomes problematic, because if your capital goes above a certain amount, it then gets taken through the charging system. Likewise, I mean, I'll use myself as an example. I do have a personal pension. I only started one a few years ago. And that's because I'm still not sure whether there is a point for me, because what is the point of paying into a pension all of your working life if when you come to claim that pension at the end, it's taken away through the charging system? So I found that the rules that we have various limiting factors. The other kind of weird offshoot from the fact that they don't take earned income into consideration is, for example, me and my wife, we're both professionals, we both work, we both earn a good salary. And at the moment, we don't pay care charges because our earned income isn't taken into account, and the few benefits that we get don't come above the threshold for charging. Whereas a disabled person who cannot work and is living on out of work benefits will be charged more than us, because the income that they get is chargeable. Now, I'm not saying the answer to that is to charge working people, but the system just needs looking at, I think, in terms of fairness.
Yeah, and that's exactly the point, you know, that we'll be speaking about in a little later, or one of the points at least, that the case that I mentioned before, SH versus Norfolk Council, touches upon that disproportionate impact that the charging regimes could have on people who are more severely disabled than those people who might be working, for example. That's how it's put in the case, at least. Anyway, I'm not quite sure if severely disabled people can't work, really, you know, but at least that's how it's framed in the case, anyway. So, Belinda,
can I say something there?
Yeah.
From the input I'm receiving from people who work in the charging sector, their perception is that very few severely disabled people do work. But they're also of the view that there's no automatic correlation between getting the enhanced disability premium or getting severe disability premium and being able to work or not. If you get EDP, you don't have to work, but that doesn't mean that, you know, you don't have to work, you don't have to keep trying to work in order to keep the benefit, but it doesn't mean that you will or will not be working. And interestingly now, whether it was in the guidance or not, I'm not sure, back in 2006, but now it's in the regulations that they cannot take income from earnings into account. So, you know, one of the horrible things about this legislation is the prospect of the government deciding to level up as opposed to leveling down, or whichever way around you want to put that, and taking away the disregard of disabled people's earnings.
Which is exactly the point you were coming to a second ago, wasn't it, Lawrence? About you don't want people who are earning to be charged more.
That's not the way to go, but there is an unfairness there. I think as well, in the minds of the average member of the public, I mean, a lot of people, I don't think, realise that social care is charged for at all. I think a lot of people think of it as part of the NHS, which in their head will make it free. But I think part of the kind of ethos is when they commonly talk about charging, they talk about older people, and the argument put forward, rightly or wrongly, is that you worked all your life, you have savings, you have a pension, and therefore you should contribute. Well, that argument doesn't really work for working age disabled people, particularly someone like myself who's been disabled since birth. So for all of my life, for my adult life, I've certainly been potentially subject to charging, and therefore haven't had the chance to accrue capital and saving for later life.
Yes. And certainly, I think when the government talks about the funding crisis and fails to do anything about it, it's always older people and care home funding that is being seen as being the crisis thing, because it's so politically controversial to be taking people's last 50,000 off of them if they have worked all of their lives. And I think that there is a real lack of fit between the fact that this country needs to look after people who have disabilities from birth to be a civilized society, but at the same time, nobody pays enough tax to cope with the jeopardy of being one of those people who, when they get old, really needs an awful lot of care. So no government wants to stop taking older people's housing and pension wealth from them, because it wouldn't be it wouldn't be affordable. But neither do they want to do anything else about it in terms of raising tax, because that would be too unattractive politically. And that's why there's just paralysis, I think, in any government about that.
I remember, I'm long enough in the tooth to remember the Pre-Community Care Act circumstances there where people didn't pay anything. I remember people just getting the old home help used to come around. There was no charges levied on them at all, and people could pay for obviously better services if they wanted to. But other than that, the state paid for. Because one of the things that people really struggle with, I was chatting to a guy who's got learning disabilities last week, and one of the things that he really struggles with is the concept, the understanding, if you like, of the state providing you with services and then the state giving you money as well for your benefits, and then the state taking back some of that money, if you like, to pay for those services that state's given to you as well. And conceptually, that was a really hard thing for him to bend his head around. And I understand that, quite honestly, as well. I understand how it would be difficult for him to get that as well. And I wonder if that might be a point, Belinda, that we could just talk about what you know, that change, because it was quite a seismic change that the Care Act 2014 brought into the charging regulations, wasn't it?
Yeah, just to say it as well, though, it's also a really inefficient way to do it. To set up one system to give people money and then set up a completely different system to get that same money back off them.
Well, yeah, you're right. Out of interest, I couldn't resist a couple of weeks ago when we started this campaign from CASCAIDr, trying to plot the history of charging for care as best as I could, both politically and principally. And actually what I found myself doing was I found a thread of law all the way back to the poor laws in the 1300s, in the 14th century, poor laws that were amazing, really, because actually, of course, they should have been called, in my view at least, should have been called the wealth laws, not the poor laws, because they were about maintaining the wealth of the rich people at that point in time. And I find it really interesting that the connivings, if you like, that have gone on since then. So we're at this stage now where the state's giving you stuff and taking it away, you know, so with the same hand. And I was wondering if you could unpack that a little bit, Belinda, maybe, and explain it to some people.
Well, I can't go back to that century,
Well, no.
but what I can say is that the big difference with the Care Act is that before the Care Act, it was mandatory to charge for care home care if the local authority made the placement. And there was a discretion as to whether to charge for care at home. Now, since 2015, the system has been that all there is a discretion. Whether it's in a care home or for care at home, there is only a discretion to charge. But every authority, except as far as I know, Hammersmith and Fulham, of course continues to charge for care homes because that was the only way they were ever paid for, through older people's pension wealth. But every authority I know, apart from Hammersmith and Fulham, charges for home care. In Wales, it's different. People are charged for home care, but there's a maximum of £80 a week that the Welsh government has laid down through some mechanism or another. Whereas, of course, the fatal thing in this country is you've got 150 odd councils and 22 in Wales, but 150 here, making their own policies up. But that's what has led to the judicial review potential. Because when a local authority exercises discretion, it may not realise it, but it has to do so according to public law principles. And if it doesn't, it can be judicially reviewed. So the fantastic thing is that whereas it's going to be hard to challenge the regulations about the benefits or the regulations about the minimum income guarantee, for instance, every single local authority is now obliged to exercise discretion and use their brains to decide what to do. And that will inevitably mean that charging law becomes a juicy, fruitful area for legal challenges to what a particular local authority has done.
Of course, because the minimum income guarantee, Laurence, essentially at least, explained what that looked like, even pre-Care Act, when all that money was taken off the person and she lost all her inheritance.
Yeah.
And she was left with enough money to be able to feed herself, I think you were saying, Laurence, was it?
Yeah, I'm going to take a risk and quote legislation at you two.
Okay.
I think it might have been the Health and Social Services and Social Security Adjudications Act in 1983 that first opened the way to local authorities charging. I may be wrong here, but I'm sure someone told me when I was doing the work that it wasn't necessarily social services that they had in mind. It was like any local authority services, things like the bins. But local authorities grabbed it with both hands, because social services is by far their biggest expense.
Mm, mm,
Mm.
yeah.
Yeah. I think that's a fair point. I wouldn't be at all surprised, actually, you know, if that wasn't correct. I never thought about it like that, actually, but yeah, for sure. Yeah. So Belinda, you know, this recent case that was, I think the ruling came out in December 2020, wasn't it? SH versus Norfolk. What happened there?
Well, that was a case in which a lady with Down syndrome who was on the enhanced rate of the disability premium through one or other of the disability benefits, found through people advising her that she was paying disproportionately a larger percentage of her overall income than people who were less disabled than she was.
Mm.
And whereas when you first think about that, the obvious thought is, well, if you're more severely disabled, you get more money. You get more money because you need more care. It doesn't immediately strike people as unfair that that person should pay more. But when you think about it in terms of a percentage of overall income, it seemed that there was the problem, as Laurence has mentioned, that people who are less disabled and who are therefore more likely to be able to work not only were paying less, but were able theoretically to keep the whole of their salaries. And therefore, in terms of a percentage, Miss SH was going to be charged really disproportionately more savagely in terms of a percentage than people who were just the next category down from her in terms of the degree of disability, if you think that that can be inferred from benefits categories. What the case didn't go into was that there's a whole set of people above Miss SH who get paid more benefits, not because they're more disabled, but because of their living situation, and in particular people in supported living. And when you look at the percentage that they pay, even though they're supposed to be enjoying independent living, it's even more massive than it was for Miss SH. So not only was Norfolk found to have acted contrary to human rights in terms of Article 14, which prohibits discrimination in and about the enjoyment of other human rights, such as Article 1 of the First Protocol, the right to respect for one's possessions. One's benefits are one's possession once they've been paid over. They were also found to have acted unlawfully with respect to not following the government exhortation not to just leave people with the minimum income guarantee, but to give people some other kind of disregard that reflects the fact that they shouldn't just have to eat and keep themselves dressed and, you know, pay their utilities. So for two reasons, therefore, Norfolk's policy had to be wiped out. They have to recalculate the charges and repay people who were affected in the light of the judgment. And they have apparently set £1 million aside to pay back 3,220 odd people. Now, as an average, that's only about 312 quid each, which is not going to pay for a lockdown treat. But on the other hand, we know people in Norfolk who have already been offered their 2,500 back, which is a significant sum of money. Norfolk is not paying interest, interestingly enough, but maybe they don't feel they need to because they only moved to taking the minimum income guarantee last year. But there will be people in similar situations all over the country who will be owed maybe 3 or 4 years of a sum of money, not the whole of their charges, but a discount from their charges, and they should be paid interest. So when you start to do the maths, you can see how significant the case would be if it was authority for the proposition that just because Norfolk acted unlawfully, if you've got a local policy that looks like Norfolk's, then your local authority's policy must also be unlawful. But we don't think that that is what the law will be found to be. So what we're worried about, and I think that we have good reason in terms of legal knowledge, we think that it's not authority for the proposition that all similar policies are automatically discriminatory. And therefore, the interesting thing becomes, how should we then take this forwards for the benefit of the maximum number of people, if everybody has theoretically got to assert a claim? Now, back in the early 2000s, when Section 117 charges for mental health aftercare were found to be unlawful, that was a black and white, crystal clear question. Any authority that had been charging needed to pay the whole of the charges back. This is a grey question. This is a nuanced question, turning on justification and turning on the extent to which local authorities ever properly consulted, quite possibly. So it isn't just going to be a bun fight for £150 million of some kind of scheme that the government will underwrite. I think the government will expect local authorities to find the money themselves. And therefore, every local authority is likely to tough it out. And the irony is that they're doing this raiding of people's assets because central government has raided the assets for social care in and of itself. So it's to do with, I think, it being an easier target to do financial assessments in a harsher way than it is for local government to fight central government, which is really, I think, an unattractive but truthful way of looking at it.
Well, unattractive is a kind word to talk about. So as far as the CASCAIDr campaign is concerned, then, Belinda, maybe you could explain what we're doing about it from CASCAIDr's perspective.
Yes, well, we know we can't give legal advice to that many people. We would just sink under the tsunami of need. And we think that there's lots of other ways to skin a cat. So what we've done is crowdfunded on Crowd Justice for £6,000 up front to go to the barristers who won the case, but to then ask them to give advice at a generic level about points such as I have just recently tried to explain there, and also to drill down to some of the ways in which councils do try to mitigate against the discriminatory effect of what they do. And the most obvious way is through the disability related expenditure policy. Lots of local authorities give people £10 a week or £20 a week. And then when you say to them, but my expenditure is more and different, they say, bring your receipts and we'll look at them. And when they look at your receipts, they all magically say, well, our £10 a week already covers that, but there was never any list of what the £10 a week was for. So if you take 35 people and they're all told that the £10 a week covers every single thing that every single one of the 35 people has put forward, you would see that it is just a euphemism. £10 a week is a euphemism for how we meet the government guidance that we shouldn't take absolutely everything off of people. We'll take everything except £10 a week. And Norfolk was already doing that. Norfolk already had that kind of a policy. So local authorities can't just say, we sort it out through the DRE. The judge was not remotely impressed by that argument because he said, getting DRE deducted is a bit like the devil's own job. There is a duty to deduct it, but to get the local authority to agree what counts as DRE is the much harder thing.
I promise you, I've been in those conversations. I'm sure you have as well. I've been in those conversations with local authorities myself. It's surreal sometimes.
Yes. So when we wrote that's why when we wrote to local authorities and we asked them, what were they doing about the approach of the case, given that it isn't just about people in Miss SH's position, it's all sorts of people. When we asked all local authorities what they did, a lot of them just wrote back and said, our policy isn't like Norfolk's.
Yeah.
But we have been doing the research slowly and, consistently, and we have found 4 or 5 techniques of trying to say that we're not doing a Norfolk. And so we've asked the barristers what they think of those 5 wheezes, if you like, and the advice will be then made public. This is the key thing. The advice will be made public so as to force better engagement with charging officers. Right. And that's one of the most appalling things about the charging system. The charging officers have got no empathy and no understanding of what it's really like to be disabled and have to decide whether to do this with your money or to do that, when doing that might prevent you from deteriorating. That's the really hard thing, I think. They're not social workers.
What do you think about that, Laurence, as a conceptual idea, using the crowd justice funding kind of approach to that kind of ultimate universal piece of advice?
Well, I think it's good in that, as Belinda said, we're talking about thousands and thousands of people. And CASCAIDr couldn't help them all individually, and lots of those people possibly haven't got access to advocacy and legal advocacy, and to fight themselves. So having advice made public seems like a good way to go. I've got my one kind of worry is that if you make it public, the local authority can see it as well.
Good. That's the idea.
And they then come up with more ways.
Well, yeah.
But it's a good point, Laurence, because one of the answers that we got back from councils when we said to them, 150 of them, what are you doing about this, was the general answer, if I got an answer at all, was we are awaiting advice. And it turns out that the National Association of Financial Assessment Officers and ADAS, that's the Directors of Social Services Members Group, those 2 organisations in some way are either shaping or funding or both the obtaining of a piece of advice for all local authorities. And there is no doubt they need that advice because it's a difficult question of law. That advice, I would have thought, should be made public. But I have a feeling that it hasn't landed as yet, because one of the things behind this campaign that we're running is that there should be transparency. And we think that maybe our campaign is making them think, could we write an advice so that the government advice, the local government advice, could also be made public? And I wouldn't have anything against that. I just think that you need to see one set of opinion against another to form a view about what sounds the most credible. I just wish that we could have timed ours on the back of the other advice so that it was comprehensive in terms of what it covers. But I think it's quite interesting. Back in the early 2000s, when the Section 117 money had to be handed back, the Ombudsman weighed in and provided a public interest report as to how local authorities should and should not be going about it. Should they be proactive or should they wait to be challenged? Would it be maladministration to just sit there and wait? And it was maladministration to sit there and wait because it was a crystal clear point of law. It was unlawful to charge. Now, because it's not the same this time round, and because the Ombudsman is well, overworked with other stuff, I have a feeling that the Ombudsman won't weigh in with a public interest report, and that will throw disabled people back on the legal aid sector. And of course, it's true to say that if you've got less than £8,000 and you don't own your own house with more than much equity in it, you can go off to a legal aid practitioner and get preliminary legal help. However, we've done the research, and out of the 51 firms countrywide that are even offering preliminary legal help in the community care field, there are only 10 of those firms nationwide who have done more than 10 cases in the last 2 quarters of the legal aid agency's statistics. So that is a tiny, tiny number of practitioners who are holding out an interest and capacity to take on work on a preliminary legal help basis.
Is it? Absolutely.
The rest of the firms that do community care will be taking important, big care issues either to the Court of Protection or to the administrative court, but they'll be doing it on a full legal aid basis. But for that, you need less than £3,000 in savings. Otherwise, you have to be paying a contribution towards your own legal aid. So we think that it is naive if people aren't aware that the legal aid sector is on its knees. And that's why we think that what we're doing is the cost-effective way of forcing charging officers to engage with the legal realities that they are governed by the Human Rights Act and they are governed by public law.
Yeah. So just coming on then to the, there are a few other sort of aspects of the CASCAIDr campaign as well, I think, Belinda, that, such as the, we said that we'd offer people an opportunity to have a financial check, basically a check of their financial assessment, sorry.
Yeah, what we're doing is we're charging a cost price to anybody who wants us to give their financial assessment the once over to just do some very basic things, like tell them whether their charging local authority is one of those that we think is in the danger zone. We want to be able to say whether we think that authority is looking bright red danger, amber, or green, probably quite squeaky clean. Yeah. And what we also want to do is to look at the individual's DRE claim, if they ever made one, and see what reasons they were given for being turned down for a disability-related deduction. Yes. The classic one is you can go out 3 times a week and pay for the transport and pay for this, that, and the other, maybe even the ticket into something, but any more than 3 times a week is a lifestyle choice. It's a want, it's not a need. And we think that that is overlooking that for disabled people, leisure and recreation is probably the primary or the only way a person gets to develop their personality and their potential in the context of society, since they cannot work. So we think that's a good point too.
Yeah. It is not a human rights aspect. So.
Yes, that is the human rights point. It's an Article 8 point there.
Yeah.
So I'm thinking that there's a lot to be said for a charging check, but I don't want it to be offensive to anybody that as a charity we have to charge. We are charging cost price for that. And the point, I think, is that people maybe overlook this sometimes. The expertise required to give people legal advice in a specialist area that is full of nuance and not crystal clear binary questions, that has to be paid for. And the only way we have caseworkers who are any good is because they have got some acumen and some skills, and they've done some training, and they know how to apply law. So for me, the viability of the charity for its wider work depends on us doing good things here, but not doing everything for free.
Okay. So listen, I'm just conscious of that we're coming to the end of our hour now, really. And so I just like to thank you both really for joining this conversation. I found it really interesting. I think that's been a really quite a deep dive into the and a whistle-stop tour of care charging from the 13th century onwards, actually, I think.
It's been a pleasure, been a pleasure.
And so thanks very much. What we'll do is we will put the links to both the CASCAIDr campaign and the CASCAIDr site actually as well, which is absolutely jam-packed with really good information about, you know, sort of recent court decisions, local ombudsman, the local government ombudsman's decisions, everything there, together with interpretations and advice around those things as well. So listen, thank you very much both for joining us, and
it's a pleasure.
hopefully we'll be able to see this campaign through with some really good positive outcomes for people. Thank you.
Thank you, Lawrence. Cheers.
Yes, thanks a lot.